And welcome to the LawNewz Network. My name is Stephanie L. Willis, and I'll be your host this morning from 9 to 11. Thank you so much for being with us today. It's a wonderful day. I hope you all had a great weekend, but we're ready to get started. Here today, we're going to be talking about the Stephen Jones case. As you know, the LawNewz Network covered the Stephen Jones matter a couple of months ago, in which Stephen Jones was charged with first-degree murder of Colin Brew out in Arizona. The exact county is Coconino County. It's being held, the trial was held before Judge Dan Slayton. However, a mistrial was declared due to the fact that there was a hung jury.
Stephen is aware
Stephen
that
Jones
his friends Shay and Jacob are still somewhere in this group with these people who are less than friendly.
Nick Piring, and Kyle Zentik. So at this point in time, what we have right now is the trial is scheduled to move forward on October the 10th. However, the defense has recently filed a motion to disqualify the DA's office in this case. And so we actually have a great guest with us this morning. We have Adam Gana, with us this morning. He is a litigation attorney, both out of state and federal courts. He practices both in New York and Chicago. Adam, thank you so much for being with us this morning.
Hi, Stephanie. Thank you for having me.
And sorry to have you wake up so early this morning. I know that you're on Central Time, but we certainly appreciate you. And we'd love to pick your legal brain and get some commentary from you in regards to this Stephen Jones matter, because we know that it's not very often that we find that the defense attorneys will file for a motion to disqualify unless it's like something that's really egregious. So we have here in this case that the defense attorneys here, I believe it's Joshua Davidson, filed a motion to have the DA's office disqualified because of a civil case that it has recently been filed. Tell us a little bit about that. What are you thinking about the defense attorneys filing this now?
Well, Stephanie, there are two issues here.
Yeah.
The first issue is disqualification, and the second issue is recusal. Those are two different issues.
Right.
And I'll get to both of those in a second. The first thing we have to talk about, though, is disqualification. Should the prosecutor be disqualified in this particular matter because his previous firm, before becoming the district attorney, is representing the families of the victims in a civil matter? The first question the judge is going to have to ask himself is whether or not the district attorney is getting any pecuniary interest in the civil matter. Because if he is, then a verdict against the defendant would benefit him financially. So that's the first thing he needs to figure out. Because his old partners could potentially get a pecuniary interest, it should be incumbent upon the prosecutor to recuse himself, because you don't want the appearance of impropriety in a case like this. I heard about a case the other day where a prosecutor was disqualified because he had offered he represented the defendant's ex-wife in a matter and offered him a settlement in that case to not prosecute him in his criminal case. And that's why you don't want a pecuniary interest going towards the prosecutor in these types of cases. They need to be separated. And so I think it's incumbent upon the prosecutor in this particular matter to recuse himself in this trial.
Well, I mean, don't you, I'm playing devil's advocate here.
Sure.
But don't you find it odd that the defense attorneys decided to file this motion to disqualify now at this point? I mean, the trial happened. So why, a few weeks before the retrial is supposed to happen, why now? Why do you think that, this is happening now? Why do you think the defense attorneys decided to actually file this motion to disqualify at this point?
Optically, it does not look good for the defendants to have a full evidentiary trial and then to try to disqualify a prosecutor. But like I said, there's a difference between disqualification. I don't think that the judge should disqualify the prosecutor. That standard is very high. Mm-hmm. But to maintain the appearance of propriety, I do think that the prosecutor needs to recuse himself from this matter.
Right. And, one thing that I thought of was probably the reason why I guess the defense attorneys maybe decided not to do it at this point or until this point, excuse me, was probably because, the families were recently served with a civil lawsuit last month. So maybe they thought prior to that point, the suit wasn't actually ripe for, or the motion, excuse me, wasn't actually ripe at that point in time. So, I would love to, pick the brains of the defense attorneys in this case, just to try to figure out exactly why now at this point, after there was a whole trial, would you have decided to file this motion to disqualify? Another thing that I thought was interesting, however, is the fact that during the actual trial, the defense attorneys did bring up the fact that Stephen Jones's father was listed as a witness for the prosecution. However, he was ultimately never called. The defense attorneys stated that this was used as a tactic by the DA's office, in essence, to kind of help the civil lawsuit, because the DA's office was then in turn allowed to have Stephen Jones's father come in for an interview, and the defense attorneys actually alleged that this interview was actually handed off to the attorneys that were handling the civil matter from William Rings's prior office. So what are you thinking about that? I mean, if that's the case, then there really is a conflict of interest here, and it would be incumbent upon the judge in this case to actually disqualify the DA's office, because they in turn had a hand to play in the conflict of interest. So tell me, what are your thoughts on that?
You're absolutely right. If the defense counsel can prove that the DA's office was soliciting witnesses in the criminal trial to help facilitate discovery in the civil trial for the prosecutor's former firm, then absolutely the prosecutor needs to be disqualified by the judge. But before it even gets to that point, I think the prosecutor needs to think long and hard about whether or not
Officer Park put him in handcuffs and put him in the back of the patrol car so he could attend to the wounded.
The fact that
you see, when the police arrived, they didn't have much information.
And when you were
they had information that there was an active shooter on campus, but they didn't know who was wounded or how many. And when they got there, it was about
just to recuse himself and to allow the Attorney General to take over.
I agree with you. I agree with you here, especially since the motion here is claiming that it violates the defendant's rights under the 14th Amendment, for a conflict-free prosecution. We all know that prosecutors are not, the victims in this case. The prosecutor's office, does not represent the victim. The duty of the DA's office is to carry out justice. So at this point, if there is some kind of a tie between the DA's office here and, Mr. Ring's old law firm, that's something that needs to be considered, and that's something that should actually be taken very seriously, because if it's looked upon that the DA's office is actually helping Mr. Ring's former employers, then there's a miscarriage of justice here, and it goes to show that to the public that maybe there's something going on here with the DA's office, and maybe we won't be able to trust them in the future. What are your thoughts on that?
Right. That's absolutely right.
Right. So what we're going to do right now is we're going to throw to a clip. We're going to go to the prosecutor's opening statements, just so that we can bring everyone in onto the case as to how it first started out, because there was some controversy a little bit leading into the case during the prosecution's opening statements. So we'll lead into that a little bit. We'll check that out right now. Stay tuned.
The defendant, Stephen Jones, murdered a young man and seriously injured 3 others because his pride was hurt. In the early morning hours of October 9th, 2015, the defendant was confronted by a group of college students, and he was punched one time in the face. Instead of punching back or walking away altogether, the defendant went to his car to get his gun, a fully loaded .40 caliber handgun, and then he went another 90 feet back toward that group to shoot 4 unarmed college students. Now, these college students were Nick Peering, Nick Prado, Kyle Zentek, and Colin Brew. The defendant shot Nick Peering twice, once in his arm and once in his hip. He shot Nick Prado once through his neck. He shot Kyle Zentek twice in his back as Kyle was running away. Now, miraculously, these 3 victims survived. Sadly, Colin Brew did not survive the defendant's rampage. The defendant shot Colin twice in his torso, lacerating vessels to his heart, causing massive internal bleeding. Colin died within minutes after the defendant shot him. Now, before this night, none of these victims knew the defendant, never associated with him, didn't know him to like him or dislike him. But that night, to the victims, the defendant was an assassin emerging from the darkness, and they had no chance to protect themselves before the defendant unloaded 10 rounds from his gun and changed their lives forever. All this because the defendant wanted payback. Now, ladies and gentlemen, during this trial, you will learn that what the defendant did was not an accident. It was not self-defense. This was aggravated assault, and it was premeditated murder. Now, earlier that night, the defendant and 3 of his friends decided to go to a party off campus, off NAU campus, Northern Arizona University. And the defendant's 3 friends that night were Shay McConnell, Jacob Mike, and Hunter Todd. All of them were freshmen at NAU, all of them newly pledged members of the Sigma Chi fraternity. Now, the defendant was driving that night, and he and his friends to this location. This is a 2-scale diagram, you'll see this during trial, of the parking lot where the defendant parked his car, and ultimately the area where the defendant shot the 4 victims in this case. The defendant parked his car here, and then he and his friends walked across the parking lot and up Franklin Avenue toward an area called the Grove, where the party was at. Now, at the Grove, like many college parties across America, there was alcohol, and some of them had some drinks, but nothing excessive. And at around 1 a.m., the defendant's 3 friends walked back down Franklin Avenue, the same way they had come, across this area near the courtyard. Now, the courtyard was a location that right across the street from Mountain View Dorm, just off NAU campus. And at around that time, there was another party, a separate party occurring at the courtyard. Now, the courtyard housed a number of members of the Delta Chi fraternity as well as the Sigma Chi fraternity, the same fraternity the defendant and his friends had recently pledged to. Now, the courtyard also housed 2 of the victims in this case, Colin Brew and Nick Peering. Well, at this party at the courtyard, just like the party the defendant attended, there was alcohol. And you'll hear that the victims in this case all had quite a few drinks that night. You'll also hear that none of them were in a particularly bad mood that night. In fact, the party was pretty uneventful. At around 1 a.m. that morning on October 9th, this party was winding down. People were leaving the party or were just about to leave. It was at that point that the defendant and his 3 friends were nearing the courtyard area, coming down Franklin Avenue. And one of the defendant's friends, Hunter Todd, decided to leave the group and go into the courtyard to visit some friends. Now, he didn't tell the others exactly where he was going, and so the defendant, Shay McConnell, Jacob Mike, his 2 other friends, stayed outside of the courtyard area on Franklin Avenue, tried to get a hold of Hunter, didn't know exactly where he'd gone. And as they waited outside that area, Jacob Mike, one of the defendant's friends, had an idea that he thought would be funny, which was to go knock on the door to one of the houses in this courtyard complex and then to leave. Doorbell ditch. Nothing sinister, just a little prank. And so he did. He knocked on the door to one of these houses, and then he and the defendant and Shay McConnell, the other friend, started walking across the street. At this point, the door to that house opened, and a group or a handful of college students came out into the street, and they confronted the defendant and his 2 friends, asked them what they were doing there. Now, it didn't appear that either group knew each other. But as sometimes happens with young men, especially when alcohol is involved, tempers began to flare. And there were some words exchanged and chest puffing in the street. And pretty soon these two groups are squared off in the road in this approximate area, and it looked like a fight might break out. At this point, one of the partygoers from the courtyard area ran up and punched the defendant in the face. Now you'll hear during trial that there was only one person that punched anybody in the face that night, and it was Austin Contreras, who is not one of the victims in this case. Now it's unclear why Austin decided to do that, but he did, and after he punched the defendant in the face, he ran off from that area. Had no further interaction with that confrontation. Now it's important to understand that at this point, of the 4 victims, the defendant migrated onto the sidewalk that separated Mountain View dorm from this parking lot area. And the words were going back and forth, but they weren't overly aggressive. In fact, the words being exchanged were words to the effect of "get out of here," mixed with some profanity. Nobody was punching anybody, kicking anyone. There was nobody surrounded. People in Mountain View dorm actually were now watching this interaction. They could hear the argument happening. And they'll also testify in this case that they didn't see any physical interaction. It was merely a verbal argument. The dynamic of that situation was about to change drastically when the defendant got to his car. You'll see this photo during trial. This is the defendant's car, parked in that same stall indicated in the diagram before. When the defendant got to his car, he didn't stay there. He didn't drive away. He reached into his glove box and he pulled out his handgun. You'll see this as well. This is the defendant's handgun retrieved at the scene, .40 caliber. It had a magazine extender on it, which meant he could shoot up to 17 rounds. It had a light attached to it that you can see here, which allowed him to shoot in the dark. The other advantage this light gave him was that it would blind his targets. The defendant chambered around, racked that gun, turned on that light attached to his gun. He was armed for battle. But it was a battle only he knew about. You see, while he was in his car, there was nobody around. He was alone. He was a man on an island. And while he was in his car, there was no threat to his safety. In fact, with that gun in his hand, he was the most deadly person in sight. Well, the defendant decided at that point that he was not going to stay in his car. He was going to walk across that parking lot. And it's hard to see in this photograph because it was taken at night. But you see the defendant's car in the foreground, and you see lights on a building in the background. Those are lights on Mountain View dorm. He walked across this dark parking lot approximately 90 feet toward the corner where this group was arguing. Again, having a verbal argument. Colin Brew was in that approximate location on the sidewalk. He was not fighting anybody, not punching anyone. He had no weapons. In fact, nobody out there that night had any weapons except the defendant. Now, people could see the defendant approaching from the dark parking lot because of that light, and they thought somebody with a flashlight. Or maybe it was a police officer, or maybe a security guard. Nobody thought it was a gun. In fact, the defendant's own friends, Shane McConnell, Jacob Mike, will tell you, at no point did they believe that they were in a life or death situation. They did not expect a gun to show up. And yet the defendant approached. And nobody else knew what was coming. Again, Colin was in that approximate area. As the defendant approached, some people heard him say, the defendant, say something, although it's unclear what he said. One person heard, "Get on the ground," another, "Stop." Some nearby didn't hear anything at all. Nothing about a gun. Whatever the defendant may have said, Colin Brew then turned toward the defendant. And it wasn't 1 or 2 seconds later before the defendant shot Colin Brew with his weapon from just a few feet away. 2 shots in quick succession, a tactic known as a double tap. 1 bullet bored through Colin's chest, through his lung, through vessels to his heart, lodging into his spine. The other bullet bored through his shoulder near his neck, tore through a couple of his ribs. Colin fell face forward into some rocks that separated this parking lot from the sidewalk area. And he didn't get up after that. Now, these bullets entered Colin's body at a downward angle or trajectory, suggesting that Colin was leaning forward or falling when the defendant shot him. You'll see photos of this area. You'll see that this rock section where Colin fell slopes downward from the sidewalk down to the parking lot where the defendant was standing. One witness described Colin as lunging toward the defendant, although he later clarified that it was simply a step forward. Others described Colin as walking or taking a step forward with his hands at his sides. Everybody agreed that Colin was unarmed, that he had nothing in his hands, and that he said nothing aggressive to the defendant before the defendant shot him down. Now, in the moments before, one of Colin's friends and his roommate, Nick Peering, was approaching from the direction of the party, up that sidewalk. He could hear Colin's voice. He didn't know exactly what was going on, but as he approached, he could see this light. Again, this light attached to the defendant's gun. But he didn't know it was a gun, just like many in the area. All he saw was a light. And as he approached Colin and the defendant, he saw the defendant shoot his friend, and he saw Colin fall to the ground. At this point, Nick Peering was a few feet away from Colin, and he jumped over a small hedge or bush that separated the sidewalk from the rock area. And as he jumped over that hedge, the defendant turned on him as well. Shot him twice, double tap, just like he'd shot Colin. 1 bullet went through Nick Peering's arm, through his hip. Nick Peering stumbled forward. He fell onto the pavement just a few feet away from where his friend, Colin, was dying. Now, Nick Peering will tell you that he was trying to get to his friend, his roommate, his buddy who he'd seen fall to the ground. But he didn't make it. He lay there in extreme pain, unable to move. Now, at this point, people in the area were shocked, and they were horrified. Nobody expected this. Nobody expected there to be a gun at what wasn't even a fist fight, but merely a verbal argument. Some ran to Colin's aid to try to help him. One of the friends that came to Colin's aid was Nick Acevedo. Nick took Colin's head and he propped it up on his leg, and he put his hand on Colin's shirt where his wound was. He could see the blood soaking into his shirt. And as he cradled his friend, he could see the defendant in front of him still clutching onto that gun. And he asked the defendant, why? Why did you do this? And the defendant said, I don't know.
And welcome back to the Law News Network. What you were just seeing was the opening statements in the Stephen Jones trial. This trial happened back in April. We're bringing you back some footage just so that we can bring you back into exactly what happened during the trial, as we all know that the trial is scheduled to move forward on October the 10th. And I say scheduled because of the fact that the defense recently filed a motion to disqualify the DA's office in this case as a result of a potential conflict between the DA's office and the previous law firm that the actual DA, William Ring, used to be employed by. We also have on the line with us Adam Gana. Adam has been providing us with some great legal analysis regarding this case. Adam, I know that you had a chance to listen to the prosecutor's opening statements here a little bit. Now, what I really want to get into is there was a bit of a controversy a little bit at the beginning of the trial due to the fact that the prosecutor here, during his opening statements, referred to the defendant, Stephen Jones, as an assassin in the darkness. Some people were stating that that was a little bit harsh, especially due to the fact that Adam at that time was very young. He was a freshman. He didn't look like someone who, I guess, appeared to be an assassin. As an attorney who's constantly in the courtroom in both state and federal courts, do you think that that terminology, that use of language, was a bit harsh on behalf of the prosecutor's office here?
Yeah, I do believe that it was a bit harsh and unnecessary. I think that the facts in this case bear themselves out without the use of that type of language. And I think that the jury, I find juries generally smart enough to understand the facts without that type of flowery language. I think that the prosecutor generally did a very good job in his opening, but I think that that type of language, that type of inflammatory language, was unnecessary in this case. Here you have a defendant that walked back to his car to grab a gun to shoot the victims. I think that those facts speak for themselves without that type of language.
Agreed. And I'm so glad that you brought that up, because that was the next point that I was going to make. So we have here this case. It's obvious that the defense is putting on a case of self-defense here. They're claiming that Stephen Jones acted in a matter of self-defense. However, we cannot exclude the fact that Stephen Jones removed himself from the position where from the area in which he stated that he feared for his life. He removed himself and went to his car. As the prosecutor stated in his opening statements, he didn't drive away. Instead, he reached into the glove compartment, got his gun, and then we all know what happened after that, unfortunately. What are you thinking about this self-defense claim? I mean, obviously, in the previous case, the defense obviously did a great job in presenting that self-defense case, because there was a hung jury. So we know that there are a few people in that jury deliberating room who could not move past the fact that maybe Stephen Jones was in fear of his life and had and properly used his gun. As a mechanism for self-defense. So what are you thinking here? Do you think that this is going to, that they'll be able to do the same thing here in the next case?
Having watched a lot of footage from this trial, I can tell you that I think that the self-defense claim is their best claim, but also something that's very hard to prove in this particular case, in my opinion. Here you have a situation where, as you said yourself, Stephanie, the defendant removed himself from the dangerous situation. Self-defense is generally only applicable in those situations where you have no exit strategy. Here he had an exit strategy: put his foot on the gas and move away from the situation. And so I think that it's a very difficult situation, or a very difficult defense for the defendant to maintain, I think, most likely in the second trial. Also probably why they filed the motion to disqualify in the first place. They probably thought the prosecution did a great job in the first case.
So you're saying that the reason perhaps that the motion to disqualify was filed because maybe the prosecutors did too good of a job, and so maybe they just want the DA's office just to be removed. Is that what you're saying?
It's possible.
Okay, I mean that's a great theory. I mean, in essence, if the judge were to grant this motion to disqualify the entire office, which is what the defense attorneys here, which is what the defense is seeking here, then they would have to bring in a special prosecutor. And so at this point, we don't know who this special prosecutor would be. But a lot of the times, I don't know if you find this. A lot of the times, special prosecutors who are brought in are individuals who actually used to I don't want to say practice, but used to try cases at the actual DA's office and have since left, and were actually pretty good, stellar attorneys at the DA's office. So, I mean, what do you think about that?
That's right. They could also bring in the Attorney General, which also has stellar attorneys as well,
right,
at the state level as opposed to the county level. And so sometimes you have to say, be careful what you wish for, because the next prosecutor, should the disqualification motion be granted, or should the prosecutor accuse himself, could be an equally, if not greater, adversary than they currently have. The problem with a case like this, though, is the amount of man hours that have already been put into preparing a case like this. I believe there are 30 some odd witnesses in the underlying trial, and the work that goes into that is extensive. It takes an incredibly long time to prepare those kinds of witnesses.
Absolutely. So we're looking at, if there is a special prosecutor that's being brought in, there's a chance that the case may have to be scheduled at a later time. Am I correct?
That's right. It could be a much later time.
Right, much later. So to get back into the prosecutor's opening statements again, one thing that stood out to me a lot was the fact that the prosecutor was very descriptive. You know, we talked about his inflammatory language regarding the assassin in the darkness, but one thing that I really enjoyed during his opening statements was how descriptive he was. One particular portion of the opening statements, he stated that Kyle Zenting was shot in the back while running away. Now, we know that this is very important because in a self-defense case, you know, if an individual, if the aggressor is then removing themselves from, I guess, the heightened state or the dangerous state, and the individual is shot in the back, I don't know how well that goes for the self-defense claim. So I thought that was a great point that the prosecutor brought out right from the beginning in their opening statements. How are you thinking about that?
It's an excellent point, and I think it was an excellent point for the prosecutor to raise in the way that he presented it in his opening statement. You know, we as attorneys are storytellers. When we give an opening statement, we are compelled to draw in our audience, to get them committed to the story that we're telling them so that they are invested in the case throughout the entire proceeding, which is long and onerous. Your opening and your closing are your two opportunities to really draw in and to put together the story that you are trying to tell a jury or a judge.
Mm-hmm. Yeah, and that's exactly the point of opening statements. You know, we are pretty much laying out the case for the jurors so that they know what they are supposed to expect. Because as we know, it's the prosecution's burden of proof to prove beyond a reasonable doubt that, you know, in this case, Stephen Jones committed actual first-degree murder and the aggravated assault against the surviving victims in this case. Another thing that I thought was actually great, in addition to him being so descriptive about the actual acts that occurred, is he described the lay of the scene very well for the jurors as well. He described that the individuals were coming from a party. He described the fact that there was some alcohol that was being served at the party. But another thing that he stated around the area where the confrontation occurred, that individuals in a dorm were able to watch the actual confrontation occurred, and that they would testify as to the fact that there was no physical fighting, only an argument. You know, so this is laying it out for the jurors here that, you know, there's no self-defense claim here. There was no fighting. So in essence, there was nothing for Stephen Jones to be fearful for in this case. So I just thought that was a great, great point that he brought out, especially due to the fact that a lot of the times jurors are not able to go to the actual scene of where the incident occurred. So laying out, where things are placed, having pictures, having demonstrative evidence is actually very important. Is that how you feel in cases in general?
It is, and think about how he weaved in that evidence too. He didn't say, the prosecutor didn't say, they're going to raise a self-defense claim, and here are the 7 reasons why there's no self-defense. He point by point refuted the self-defense claim without ever having to say it. He goes, there was some drinking, and there were some arguments and some curses being thrown around, but there was no altercation. The defendant leaves the altercation, goes to his car, closes the door, has a moment to think, could have drove away, decided to stay, pulled out his gun, which had an extended magazine, which had a light, which he's utilizing to say this is the type of conduct that this kind of defendant was planning for. That's how he gets to his assassination claims, which, like I said, I think were over the top. But that's how he gets to those points. And he does it without having to say, these are my 7 points in response to a self-defense claim. He does it very tactfully, I think.
No, absolutely. I absolutely agree with you. And you brought up something that was very key. You said that he had a moment to think. He had an opportunity to plan. So this is going back to the fact that this is first-degree murder, because you have that intent. You have that modus operandi here. You know, especially the fact that the DA's office, or the DA trying the case, excuse me, he stated that, you know, through the bushes, people saw a flashlight moving back and forth. And at that time, they didn't even think that it was a gun. So they thought it was somebody, I guess, looking through the bushes, and they actually saw a flashlight. So that moment in time, I think, is actually very important, because of the fact that you have an individual who is scanning back and forth with what we actually know now is a gun, but people thought was a flashlight. So that shows that there was an actual moment, or moments, in which the defendant, Stephen Jones, had time to think about exactly what he was doing at that time. What do you think?
Absolutely right. It's absolutely right. I mean, you know, he had multiple moments, at least according to the prosecution. He had the moment in his car. He had his moment leading up to the car. He had the moment the car door was closed. He had the moment that he pulled out his gun. He had the moment that he started walking back. He had the moment that he was deciding whether or not to actually pull the weapon on the victims. And so I think the prosecution is saying that there were multiple moments that he had available to him where he could have turned back at any time.
Right. So we're going to continue on with the prosecution's opening statements. We're going to talk about the actual shooting of Nick Prado at this point. So we're going to get back into the prosecutor's opening statement, so we can talk a little bit more about that.
And then the defendant shot off several more rounds. Witnesses in this case will talk about hearing 2 sets of gunshots. The first set of gunshots coincides with when the defendant shot Colin Brew and Nick Peering. The second set of gunshots coincides with when the defendant brought this gun out a second time. Now, in the moments before the defendant was pushed to the ground, Nick Prado, one of the victims in this case, was near Colin, attending to him, and he had the thought that he should get a good look at this person, at this shooter, so he could identify him to the police. And so he made a conscious effort to do so. He stood up and he took a couple steps forward, and he looked down at the defendant, who was now on the ground reaching for his gun, and he saw the defendant look back at him. And he saw the defendant reach the gun out from behind him, pull it out, take aim at Nick Prado, and fire. Nick Prado heard the gunshot, felt the hit to his neck. He immediately grabbed onto it. He ran away from the area, back toward the courtyard to try to find help. Blood was coming out of his neck. He was getting dizzy. He was in shock. He managed to get back, found some help. People helped put pressure on his wound until the paramedics arrived. Now, after the defendant shot Nick Prado, you'll hear that he didn't stop shooting. He also shot the other victim in this case, Kyle Zentek. Now, Kyle was in the area when Colin and Nick Peering were shot. He doesn't have a great memory, though, about this night because of the extreme trauma that he experienced. You see, Kyle, when he was in that area, he was trying to get to Colin's body to see if he could help his friend. He recalls that the defendant brought the gun out the second time, shot Nick Prado, and then the light of that gun rested on Kyle. And he remembers distinctly that it wasn't sweeping past him, that it was directed at him. And Kyle knew that this was bad. And he turned to run away, and as he turned to run away, the defendant shot him twice in the back. Kyle kept on running as far as he could. He made it partway down the sidewalk before collapsing in extreme pain. Kyle doesn't remember the paramedics arriving. He doesn't remember the rush to the hospital or the emergency surgery that he had that night. At this point, the defendant walked away from the carnage to a nearby tree. A witness from Mountain View dorm had come out at that point, and he hadn't seen the shooting from earlier, but he could see people on the ground. He could see the defendant hiding the gun behind his back like this, and he was putting 2 and 2 together. And he asked the defendant to put the gun down, that he'd keep it safe. At this point, officers were on their way. Sirens could be heard in the air. And after the defendant shooted 4 unarmed kids, and without any options, he put the gun down. And he walked away from that scene. Officer Park put him in handcuffs. He put him in the back of his patrol car so he could attend to the wounded. You see, when the police arrived, they didn't have much information. They had information that there was an active shooter on campus, but they didn't know who was wounded or how many. And when they got there, it was a battle scene. Nick Prado was lying on a kitchen floor, clutching his neck. Kyle Zentek was writhing in pain on a sidewalk. Nick Peering was on his back, unable to move. Colin Brew was motionless on the rocks. The police tried doing CPR on Colin, but by the time the paramedics arrived, there was just nothing anybody could do. Colin died in the rocks, right where the defendant shot him. Now, Nick Peering, Nick Prado, Kyle Zentek were rushed to the hospital. Of the 3 of them, Kyle had the worst injuries. One of the bullets the defendant shot into his back pierced his bowel and also one of his kidneys. And he was sent to emergency surgery that night. Doctors actually had to remove one of his kidneys to save his life. He spent several days in the hospital afterwards, recovering. In fact, the first interview he ever did in this case was in a hospital room, while he was hooked to machines. Nick Peering fared a little better. He was shot twice as well, but one bullet went through his arm, the other through his hip, missing vital organs. He did suffer a fracture to his pelvic area, but he was able to walk after a couple of days. Nick Prado was lucky. He was shot through his neck, through and through, centimeter or 2 away from his jugular, from his carotid artery, which if hit at the scene almost certainly would have killed him. Now, while the victims were being attended to at the hospital, the police were putting the pieces together. They were talking to people who were there, who saw what the defendant did. They were photographing the evidence, the blood at the scene. And one of the things they did, you'll hear about during this case, was they took a digital scan of the area, which allowed them to take precise measurements. And because of that, we know that the defendant traveled approximately 150 feet from the point he was punched in the face to get to his car, to get to his gun. And then he had to travel another 90 feet to get to the point where he shot the 4 victims in this case. A grand total of 240 plus feet to get his gun and come back to shoot these victims. Now, while the defendant was placed in the back of that patrol car and he was sitting there, the officers were attending to the victims in the case, there was one officer, a deputy with the sheriff's office, who was standing guard. And he had a digital recorder going in his pocket, and he had a conversation with the defendant to try to figure out if there were any additional shooters. You see, they didn't know exactly what had happened, so they were asking questions. And he asked the defendant if he was the only one. The defendant said yes. And he tried to clarify, "You're the only one?" At that point, the defendant made this admission: "Nobody else did anything wrong but me." Colin Brew's body was eventually taken from the scene. It was taken to the medical examiner's office for an autopsy. And the medical examiner found the 2 bullets that killed him. One bullet lodged in his spine, the other still in his back after busting through his ribs. The medical examiner also removed approximately 2 quarts of blood from Colin's chest cavity, evidence of the internal bleeding he suffered after he was shot. What the medical examiner did not find, however, was anything on Collins' hands, suggesting that he was reaching for the defendant. No defensive wounds, no burnt or unburnt gunpowder, consistent with the witness accounts that Collins had his hands at his sides when the defendant shot him. Colin Brew was 20 years old when the defendant killed him. He was a junior at NAU, excelling at school. By any account, he had a bright future ahead of him. He was just making his decisions. He was 20 years old. His whole life was ahead of him. And the defendant, Stephen Jones, ended all of that in seconds because he wanted to retaliate, because he was punched one time in the face. Ladies and gentlemen, during this trial, you will hear from approximately 35 witnesses. It's going to take some time. Many of these witnesses were there at the scene, saw the defendant's actions. But this is not going to be like a movie where you get all the information at once for easy consumption. You're going to get this information from one witness at a time and from different perspectives. People who were being attacked by the defendant, people who were running away or watching from the sidelines. And because of that, you'll be getting the information in pieces. But as the trial progresses, these pieces will begin to fit together, and they will form a picture of murder and of an unjustified shooting. This case is not a whodunit. There's no mystery to who killed Colin Brew, who shot Nick Peering, Nick Prado, or Kyle Zentek. The defendant did. The question for you during this trial will be, what was the defendant's intent when he shot these 4 unarmed victims? And that's a question you will only be able to answer based on the evidence, based on the testimony you get from this witness stand. As we've talked about and as the judge instructed you, it cannot be based on sympathy. It cannot be based on prejudice, one side or the other. It must be based on the evidence. Now, you've received some instructions already. You haven't received all of them. You'll get more at the end of the trial. But these are the instructions that you have to follow that will give you guidance in the law. And one of the instructions you got today was about premeditation, about what that means, how it's a moment of reflection before killing someone. And it tells you that moment of reflection can be very short. And that may be different than what some of us have heard about premeditation. And that's why it's so important to keep an open mind during this process, during trial. Wait till you hear all the evidence. And wait till you get all the jury instructions in this case before making up your mind. Now, after I sit down, the defense may give an opening statement. They don't have to, but they may. And if they do, they may talk about things I haven't talked about, things that may even seem important. But rest assured that at the end of this case, the state will have an opportunity to talk to you about all the evidence you've heard. Evidence that will include the testimony of the 3 surviving victims in this case: Nick Peering, Nick Prado, Kyle Zentek. You'll hear their firsthand accounts of how the defendant attacked them unprovoked. Evidence that will include the testimony of witnesses in the Mountain View dorm, independent witnesses who saw the defendant shoot on an unsuspecting group. And evidence of the time and the travel it took the defendant to get to his car, to his gun, and then to go another 90 feet to shoot the victims in this case. Now, what the defendant, or what that initial confrontation was juvenile. It was uncalled for, that confrontation in the street. There's no doubt. And sucker punching anybody in the face is just wrong. But none of those kids deserve to get shot. And Stephen Jones does not get to decide who lives and who dies.
Objection, Your Honor. Counsel's arguing this is opening statements.
Sustained. Jury will discard.
At the end of this case, the state will ask you to hold him accountable for what he's done. For the murder of Colin Brew and for the shooting of Nick Peering, Nick Prado, and Kyle Zentek, and find him guilty on all charges. Thank you.
Welcome back to the Law News Network. We had the latter part of the prosecution's opening statements in this case. We still have Adam Gana here with us today, and I apologize for mispronouncing your name. It's so easy to pronounce, so my apologies. Adam, we had here that the prosecution is winding down in their opening statements. They're talking about the fact that Nick Prado ran to get help after he was shot in the neck, and he's bleeding profusely. We have all of this colorful language coming out in the prosecutor's opening statements. The next thing that he talked about was also the fact that Kyle Zentig was shot. One thing that he informed the jury members is the fact that Kyle really did not have a great memory of exactly what occurred, and he slipped in there the fact that he did not have a great memory because of the trauma. Now, if that were me, I generally do not like to object during opening statements. That's something that's really frowned upon, I guess, in the legal community. It's not something that we really like to do during openings or closing, unless it's something that is really far out there. But, however, I want to say that I probably would have objected a little bit, not a little bit, I would have objected. You either object or you don't. But I probably would have objected because of the fact that he's testifying during his opening statements for Kyle Zentig. He stated that Kyle Zentig did not have a great memory because of the trauma. What do you think about that? As a defense attorney, are you sitting there in your chair thinking, I can't believe he just pulled that off?
I would not have objected personally, actually. I can't remember a single time that I've ever objected during an opening statement. And the reason is, it's so easy for the prosecution or the other side to just turn around and say, is there something you don't want the jury to hear? And to make you seem as if you're trying to hide something, or that something that the prosecution wants to be important takes on an added significance in a case that doesn't need to be there. So what I would do is I'd save that moment and say, do you remember when the prosecution said in their opening statements that they tried to slip this in? This is quintessential evidence here, and I would explain why. Right. I would just try to make them seem as if they're trying to hide important evidence.
That's a great point. That's something that I generally didn't even think about. The fact that, I mean, and it does happen. Nobody wants to seem as if they're hiding evidence from the members of the jury, because when that happens, the jury members are then looking at either side and saying, well, what do you not want us to hear? Exactly, just like what you said. The next point that I thought was great by the prosecution is the fact that he brought out how long or how many feet it took for Stephen Jones to actually get to the vehicle to get to his gun. He stated that the defendant traveled approximately 150 feet to his car to get the gun, and then traveled back approximately 90 feet to the area where all the victims were shot. Altogether, a total of 240 plus feet. I thought that was very impactful. What are you thinking about that particular?
I would have played it just a little bit differently. I would have actually moved the 240 feet because sometimes it's hard for juries to conceptualize time and space. So I think examples always help. So I would have started making those moves. I would have talked about the size of the courtroom, how long it takes to get from one end to the other, things like that. Because sometimes conceptually, when you're sitting in a chair like that, it's hard to conceptualize that kind of space.
Right, and that, those are the, I guess, the great parts of being a great litigator when you're in the courtroom and you know how to actually use, what you have with you. So you use the length of the courtroom to say, okay, this courtroom is, let's say, 300 feet. So altogether, the defendant ran, 240 feet together, just so, for this act to actually transpire. Another key point here was the fact that the officer had a digital recorder and recorded the defendant stating, "No one else did anything wrong but me." How's that faring for the self-defense claims here?
I go both ways on that statement. I think the actual actions speak louder than the actual words after the event, right? So the same reason, and I would kind of equate the two. in my closing, probably if I was the prosecution. Look, the same way that he says the only one that did anything wrong was me and he didn't mean it, you know, with these types of stressful situations, people say things and forget things that they otherwise would not say or forget. And so we can give him a pass on that, but we cannot give him a pass on his actions. And that's kind of where I think I would give a little bit, actually.
Right. Now, not to jump back and forth with you, but you practice civil law as well, am I correct?
Sure.
Okay. So I just want to talk a little bit about this civil case that has been filed, you know, by the surviving victim's family. In the civil trial, excuse me, in the wrongful death suit that was filed, they are actually also filing a claim against Warren Jones, which is Stephen Jones's father, stating that they're claiming negligence on behalf of Warren Jones, stating that he actually, you know, improperly trained his son on how to use a gun. Far stretch here?
To me, yes.
Right.
I mean, you know, look, we all know that the difference between a criminal trial that requires proving something proving the defendant's conduct beyond a reasonable doubt violated the law versus civil claims which require preponderance of the evidence to prove whatever claims they make, including those of negligence. So what a reasonable person would or would not have done, I don't think that you can state with any degree of, you know, it's not a case that I think holds a lot of merit, in my personal opinion.
Okay, well, Adam, I want to thank you so much for being with us today. You provided some great insight, and we look forward to having you back on the network again. Hopefully this time it'll be on Eastern time to not get you up so early.
I'll come visit you in the studio. Thanks so much for having me, Stephanie.
Thank you so much. Thank you so much. Have a great day.
Bye-bye.
Bye-bye.